Legal dictation start. Counsel for the petitioner has further submitted that the appellate authority mainly has gone by the fact that the petitioner has admitted the pleadings raised by the respondent landlord in the eviction petition full stop. However, this conclusion of the court below is wrong full stop. The petitioner denies having admitted any pleadings raised by the respondent landlord in the eviction petition full stop. Even if the pleadings are taken as admitted, the rent authority would still have to assess the pleadings of the parties for arriving at a final decision full stop. Hence, the issues were rightly framed by the rent authority full stop. The appellate authority has wrongly set aside the order of framing of issues full stop. Still further, the court below has wrongly assumed the service of notice upon the petitioner by virtue of the fact that the petitioner continued the default in payment of the rent even after filing of the petition full stop. In such a scenario, Section 25 of the Act shall come into play full stop. The court below could have allowed the arrears of rent with statutory interest even for the period during pendency of the petition full stop. However, non-payment of rent during pendency of the eviction petition or during the pendency of the appeal is not a ground sufficient to order eviction of a tenant full stop. Hence, the order passed by the courts below are wrong full stop. On the other hand, counsel for the respondent landlord has referred to the pleadings of the parties full stop. He has submitted that after payment of rent for some months, the petitioner defaulted in its payment full stop. In the first instance, oral notice was given to the petitioner to pay the rent full stop. Thereafter, he paid the rent for some months but again defaulted in payment full stop. Therefore, the petitioner forfeits his rights to get any notice for the second time as per the proviso contained in section 20 subclause 2 of the act full stop. Counsel has further submitted that the court below has rightly held that the non-payment of rent during the pendency of the petition itself is a sufficient notice to the tenant full stop. Counsel has relied upon the judgment of the Honorable Supreme Court rendered in the case of so and so full stop. In the present case, since the petitioner did not make the payment of rent during the pendency of the rent petition or during pendency of appeal, therefore he has rightly been ordered to be evicted full stop. Qua framing of the issues, counsel for the respondent has submitted that the respondent landlord had made specific pleadings in the rent petition qua the date of agreement full stop.